You sued your doctor for medical malpractice, and now your case has been going on for 2 years. The defense finally reaches out to you and says, hey, we would like to try and mediate this case, try and negotiate this out of court before we ever get to trial. Does the fact that the defense wants to mediate your case, number one, mean that your case is going to settle? And number two, does it mean that you and your attorney don't have to prepare for trial? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so you brought a lawsuit against your doctor claiming that he was careless and that his carelessness was a cause of your injuries. And now the doctor says, why are you suing me? I did nothing wrong. Hey, you got the wrong person. And by the way, I didn't do anything wrong. You, the patient, caused your own injuries. And then they turn around and say, you know what? If I did something wrong, well, guess what? Whatever I did didn't cause or contribute to your injuries. And then the doctor and his attorney say, you know what? If I did something wrong and I caused you harm, your injuries really are not as bad as you claim them to be. And they refuse to negotiate. They refuse to engage in any settlement discussions. So now your case proceeds throughout the entire litigation process. That means that your case is likely going to trial. So now your attorney finally tells you, hey, listen, we have a trial date. We're going to trial next month. Okay, he says, listen, I need to bring you into the office to prepare you for the trial, for your questioning, for the questions I'll be asking, as well as the questions that the defense lawyer will be asking you on cross-examination. But interestingly, shortly after that discussion, your attorney calls you back and say, hey, listen, I got a surprise phone call from the defense. They want to try and negotiate this case. But they don't want to do it in a verbal conversation over the telephone just between the attorneys. They want to try and have an impartial judge known as a mediator try and help in the negotiations, known as a mediation. Does the mere fact that the defense wants to try and mediate your case, try and negotiate the case out of court, does that mean that your case is going to settle? The answer is no, it does not. It means that they're interested in trying to negotiate this case. They're interested in trying to settle the case, but by no means does it guarantee that you're going to settle your case. And I'll explain what I mean in just a moment. But let me answer the second question as well. Now that the defense has told you that they're interested in trying to negotiate this case, does that mean that the preparations for going to trial stop and that you don't have to go into your attorney's office and prepare for trial? Does that mean that your lawyer has to stop all of his preparations to go to trial? The answer again is absolutely not. You want to know why? Because if the mediation breaks down, if the settlement discussions go nowhere, now what's your only alternative? That's to continue going forward to trial. You now have to go to trial and you'll have to take a verdict. And there is extensive preparation that goes into preparing a case for trial. Under no circumstance can you and your attorney stop the preparations needed in order to go ahead and prepare your case for trial. Because I'll also tell you, preparing your case for trial actually has a significant benefit when you go ahead and try and mediate your case, when you go ahead and try and negotiate your case. Now you get your ducks all lined up, you get your witnesses lined up, you get your evidence lined up, and now you're putting your best foot forward when you go into the mediation. Judge, this case involves a failure to diagnose breast cancer involving a patient who went in complaining of a lump in her breast. And now this doctor failed to do A, B, and C. And we were going to show at trial, using the following witnesses, the following experts, that this guy violated the basic standards of medical care, causing this cancer to grow undetected for a period of over 2 years. And now this patient has advanced metastatic breast cancer and is likely going to die within the next 6 months. And now the defense will have an opportunity to go ahead and put forth their best argument to explain why the doctor did nothing wrong, to explain why whatever he did not cause or contribute to your injuries, and then to explain, hey, whatever injuries you have really are not as bad as you claim them to be. So then, after the presentations are made, now each side will have private conversations with the judge to try and understand what the opposite side's position is. So now after these presentations, I'll have an opportunity to meet with the judge privately and say, Judge, listen, this is our position. This is what we believe this case is worth. This is what other cases have resolved for. This is what other cases have gone to verdict for. And this is what the appeals process resulted in this type of case. We believe we have a very strong case. This is why we believe that the defense should be paying this amount of money. And now the judge will go back to the defense and say, hey, how much money do you have? Are you going to resolve this? Are you serious about this? How much money do you have on the table right now? Where are you willing to go? Where do you want to wind up? Where do you think this case is going to wind up in terms of a settlement amount or settlement range? And now the judge will then begin to put pressure on the defense. The judge will then begin to put pressure on us. And over the course of many hours of negotiating, hopefully the goal is to try and reach an agreement so that now each side can come to a conclusion and each side can recognize, okay, I can live with that. Yes, I can live with that. In that instance, there is the possibility that your case can be settled before ever going further. But remember what I said at the very beginning. Does the mere fact that the defense wants to mediate or try and negotiate, does it guarantee you're going to settle your case? Absolutely not. There are many times where you go into a mediation and you cannot reach a mutual agreement about the value of this case. Or you cannot reach a mutual agreement about who is liable in this case, or the percentages of liability. In that instance, now again, you've got issues that can't be resolved either in negotiation or privately, and now you have to rely on a jury to go ahead and reach those conclusions, which means you're going to trial. And you never ever want to stop the preparations for trial because there's a good likelihood you're not going to settle your case. And in that instance, you are going to trial. But let me tell you one more thing. Even if you do go to trial, there is still the possibility that the defense would be willing to negotiate. Now again, just because they were willing to mediate or try and negotiate this case earlier does not automatically mean that they're going to re-engage during the course of trial. It's a possibility. They may decide they want to, but then again, they may not. So why do I share this quick information with you? I share it with you just to give you a sense of what really goes on in these medical malpractice cases, these accident cases, and even these wrongful death cases here in New York. You know, I do understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit and have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.